Good evening, ladies and gentlemen. Welcome to our Board of Adjustment meeting for January 23rd, 2019. We have one item on our agenda tonight. If you wish to be able to make comment on that, we have some white cards in the back of the room. Please fill one of those out and hand it to our city staff members so that we can get you in our records for being a speaker. Along those lines, actually, I'd like to go ahead and clarify now. I see a couple of folks who filled these out who are, one person wrote, represents the applicant, Court Rich. Is that you?
Yes.
Okay, sorry. Sorry, I forgot your name that quickly. Okay, so you're okay. We don't need a card for you, of course. I'm just wondering whoever is part of the team can speak as much as you wish during your regular presentation. And just help me make sure that I get those straight when we get there.
Thank you. There'll be a couple of us making comment for sure.
Okay, great. All right. So, first item of business, we've considered minutes from our previous meeting of November 28th. We found a couple of corrections, which we discussed in our study session, and we are, I believe, otherwise content with them. See, I forget something every time. I'm charging right ahead without doing our introductions. Okay. Sorry, I'm a little overeager maybe. All right, so roll call tonight. Traditionally, we let each board member introduce themselves. So starting on my left, Board Member Confer, if you would grace us.
Sure. Jack Confer, board member.
I'm Chairman David Lyon.
Vice Chairman Jim Frazee.
Richard Watson, board member.
Joshua Tracy, alternate.
Okay, and also with us, we have city staff members Steve Abramson, Karen Stovall, Brittany Nelson, and in our audience, we are graced by Blake Shimke and Ryan LeVake. All right. So now moving right along, let's consider our meeting minutes from our previous meeting. Can I hear a motion regarding their approval, please? Board Member Watson.
I'd like to motion that we approve the minutes as amended in the study session.
Okay, do I hear a second?
Second.
All right, motion to approve with amendments from Board Member Watson and seconded by Vice Chair Jim Frazee. All those in favor by show of hands, please. Opposed, if any? And in abstention?
I abstain.
Okay. All right. So the motion passes 5-0, I believe. Is that what I saw? Yes? Okay. All right, so let's move on to our one and only case for the night. Ms. Stovall, if you would read us in.
Right. Right. Good evening, Chair and board members. My name is Karen Stovall, Senior Planner. This request for PL 180173 is for a site at 8611 South Priest Drive. This is an appeal of the hearing officer's decision made on July 17th, 2018 to deny a variance to reduce the required separation requirements for a medical marijuana dispensary from a residential use and from a child care facility. The site is zoned PCC1. The applicant is proposing a dispensary within a commercial condominium complex located north of the northeast corner of Priest and Warner. The first variance request was to reduce the separation requirement between a dispensary and a residential use from 1,320 feet to 890 feet. This map shows the property located at 9010 South Priest Drive, which contains the residential use. The second request was to reduce the separation requirement between a dispensary and a child care facility from 1,500 feet to 1,430 feet. And the map before you shows the property located at 1616 West Ruby Drive, which contains a licensed child care facility. Your staff report packet includes the hearing officer's staff report, the hearing minutes, the letter of appeal, and public input received leading up to and then following the July hearing. With that, unless you have any questions of me, I will allow the appellant to make his presentation.
All right, do we have any questions for Ms. Stovall? Seeing none, we will thank you. And we'll invite our applicant to come and tell us about your appeal.
Great. Good evening, Chairman, members of the board. My name is Court Rich from the Rose Law Group. I'm here today to present to you on behalf of the applicants, the owner of the building, Image Productions, and Park Dispensary, who is the proposed tenant. With me is the owner, as well as another attorney who you will be hearing from on behalf of Image Productions, specifically on a specific issue. So I have a presentation that I would like to take you through. I would note, because there was some discussion prior to this during the study session, just for the record, we have presented you with some additional documentation today. Those are in the form of various, most of the documents are city generated or other stuff that's in the record, but I want to make sure that it's in the record. It's our job. You're sitting here today as judges to give you evidence and build the record, but I will refer to those as needed during the discussion, and it's not my intent that you have read all that. Although I will also note for the record, we did try to submit that on January 11th, and we're told that you would not accept it. So let me start my presentation here and say this is really the case that variances were made for. I'm going to take you through the litany of special circumstances, the unusual occurrences, the very backwards and odd occurrences that led my client, the owner of this property, here in front of you today. And I think what you'll see by the end of this presentation is that, yeah, this really is, if there really is a case that a variance makes sense for, this is it. So I think, let me boil it down, start with the simple, and then we'll take you through some of the details. I think this is simple, and let me take you through kind of what's happened. So back in 2015, the owner of this property applied for and received approval from the city to operate a dispensary in this location. That's uncontroverted. That's what happened. The approval letter, and that's one of the documents that you've got there in that packet I handed out, which I believe is document number 3. The approval letter said the Community Development Department Planning Division has reviewed and determined that the site located at 8611 South Priest Drive, Suite 102, et cetera, is in compliance with the Zoning and Development Code, Section 3426B. So what that means is that this site worked for that applicant, for the owner of this spot. This city determined that this site was appropriate for the medical marijuana dispensary use. And there's a letter, the letter that's in your file, and an excerpt of what I just read there, just to flag it for you. From that point on, there was significant investment that was made in building out the site. The certificate of occupancy was even issued on the site. Now the building has a new owner. The owner has stepped into the shoes of the previous owner. As happens if you transfer a building with its entitlements to another owner, they receive the building with those very same entitlements. Under the city's own code, and I'll get into this in more detail, successors in interest have the same rights to approvals as the previous owners. So what's the problem? It sounded pretty simple, right? And it's my job to make it sound simple to you, but what's the problem? So the city has said, well, we've changed the rules about where you can put medical marijuana dispensaries, and we want to apply those new rules to this building. The separation requirements then require a variance, because if you're going to apply the new rules to this building, even though it qualified under the old rules, invested this money, got a C of O, and the chain of title and the owner is still in the chain of title from the old owner and the successor in interest, if the city is going to say that you can't develop that way, well, then you're going to need a variance, and that's why we're here for you in front of you today. Is the city is denying the new owner the rights that the previous owner had, and that the city confirmed that they had in that letter that you've seen. So can the city do this? My answer is no. The city really can't tell an owner that has the rights to develop a piece of property and that, based on the city's own code, inherited those rights from the previous owner. They can't really tell you that you can't do, you can't develop it. But if they're going to say no, then the only option here is to come for this variance. So the applicant is the successor in interest to the original owner, and the original owner was a company called Pathfinder. Pathfinder is the owner on whose behalf Natural Herbal Remedies, which was the original dispensary that was going to locate here, they applied to the city and said, we want to locate in this location. Now, that application was made on behalf of the owner. And how do I know that? Because, well, your city code says that to initiate an application, it must be initiated either by the city council or by the owner of the subject parcel. So it was clearly the owner that had to come in with the application asking your city if they could locate a medical marijuana dispensary there. And here's, the owner of the subject parcel is who has to be the applicant. And then it says the property owner's written authorization shall be required for any application. And now that's in your packet that I gave you, as well as, it's number 1 in that packet, is the owner authorization that was originally signed by this company, Pathfinder. Well, what does Pathfinder have to do with this? There's the excerpt from that owner authorization right there, where they wrote to the city and said, this Natural Herbal Remedies can go and apply on my behalf. So how do we get from Pathfinder to Image Production, who owns the property today? Well, here's a series of deeds that take you from one entity to the other, ultimately to Image Productions. And those are all in your packet as number 5, where it's titled Chain of Title. So clearly, we have this chain of title from owner to the applicant that's here before you. So the city also has never taken any position on revoking any permits that have been given. Your code has a whole procedure for revoking permits. That has never happened. The city even admits that Natural Herbal could still open there if it wanted to. In fact, Natural Herbal, during one of the previous times that this issue came before the Board of Adjustment, you were told by one of the city attorney's office members that, yeah, if Natural Herbal were before you today, they would still be able to open. So the only way that they can open is if they have a right. That right attaches with the landowner, and the landowner, the building owner now is my client. And so now I think you're getting a sense of why I said this is the sort of the case that variances are made for. This is a weird situation that I'm sure the city of Tempe has probably never seen before. Here is where, in the record and in the documents that I provided to you, the minutes from the Board of Adjustment minutes, it's number 6 in those documents, an excerpt from there where we were told that a medical marijuana dispensary at this location was approved. The city reconfirmed that they approved it, and that approval remains active at this time. That was during this last hearing from 2017. And additionally, there was a back and forth between the chairman at the time and one of the city representatives who said that Natural Herbal Remedies would still be allowed under this established permit that was in place. So the approval remains, it has to remain with the owner by the language of your ordinance that says that these approvals run with the owner of the property. Successors and interests maintain the approvals. It simply has to be with my client at this point. There's no other way, there's no other place that approval could be. So what's the solution to this unique and special circumstance? Grant this variance. Now, as you've heard, variance has a 4-part test, and I know you discussed it really briefly prior to this in your study session. And what's unique about that is that when you apply this test, you all are sitting there as judges. And as judges, you really are told that you're looking at these 4 tests. You're not looking at, at the meeting in front of the hearing officer, there were several members of the public that came out and said that they really love this. They have children that need treatment, and it would be great to be able to have access to the certain type of medicine that Park Dispensary wants to provide. But the hearing officer can't consider that. No more can they consider there are some folks in the building next to my client who don't want him there. But that's not one of these tests. It's not what does your neighbor think, what does the guy down the street want? It's these tests, and that's what your duty is to apply. So you guys are judges in this situation. So I'll take you through these one by one. Sorry to have to do it, but I think it's really important. So the special circumstances. In this case, the special circumstances I think are literally as special as they can get. So use permits and approvals, as I said earlier under your code, are transferable to successors in interest. That's your 6-903 in your code. My client is the successor in interest to the person who holds the permit to operate the dispensary in this location. The approval was assigned, and I've got that in your, just to be clear for you all, your code says they're assignable. It was assigned. That's number 4 in the packet that I provided to you. So the fact that the city is refusing to acknowledge what its own code says is clearly a special circumstance in this case. We're not asking you to make any ruling that says that they don't, that they have another way, they don't need the variance, they don't, that anything else is going on. The solution to this problem is just to grant the variance. Ignoring these legal transfers creates these special circumstances. There's already approved for a dispensary site and built out at this location before the law changed. The client invested a lot of money in building the site. The changes in law eliminated nearly every single possible dispensary location in the city of Tempe. And this is important. There was a question during your study session, I think it was Board Member Cullens asked why I included a case in that packet. I think the case is number 8 in your packet. So that is a case where the court has ruled, and it's not with regard to my client, but it's with regard to the city of Tempe and its treatment of medical marijuana dispensaries. And the court ruled that special circumstances are created by the fact that the city's code changes have made it almost impossible to locate a dispensary in the city of Tempe. And so the city was pushing back and saying, well, and this is more relevant to a test later, and I'll touch on it in more depth, but the city was pushing back, suggesting that the fact that there weren't many or any other viable locations for medical marijuana somehow meant that these tests, that the applicant couldn't pass these tests, and the court said, no. In fact, that is a really important factor in deciding whether or not this variance should be granted, and I'll take you through that in test number 4. So let me summarize kind of what's going on with this. There's no other dispensary in this exact circumstance. You want special circumstances? I don't think you've seen a case like this. To my knowledge, there's no other case pending in the city of Tempe remotely like this. This is so specific to this applicant. There's been an approved dispensary in this location. An acceptance letter was issued. We complied with the laws that were in place at the time of the application. Building permits were issued. Money was spent. The site was built out. The new owner has an assignment, is the successor in interest to the previous owner, received C of Os. Then the law was changed. Now the city's refusing to honor the transfer. I'm just trying to take you through how unique and weird this is. There's this daycare facility. I think you all even heard about this, those of you that were on this board in 2017. The daycare facility is not even your traditional daycare facility. It's a place inside of a gym where people drop off their kids while they are working out. So it's not as if it's a preschool or anything like that. This is further unique circumstances here. And the setback increased on the residential side more than 100% as a result of the change in the law. So I ask you to imagine yourself as a business owner, a building owner, and you're put up against this litany of changes and oddities, and think about what you think would be the fair result under those circumstances. So I don't think it gets any more special other than this, and we pass that test number 1. The test number 2 that says that the strict application of this code will deprive the property of privileges enjoyed by other property of the same classification in the same zoning district. I would submit to you that we clearly meet this test. So medical marijuana dispensaries are permitted in this zoning district. They're permitted in this exact location when we were issued the permit by the city. Went and built out the facility. Anyone else who was issued a permit back before the law changed that built out the facility that wanted to move in would be permitted to. So we are being deprived of rights. My client is being deprived of rights that others in the area are not being deprived of. So applying these new distance requirements that are inapplicable deprives him of his rights. The predecessors in interest got permitted and built out the site under the rules that were in place at that time. And sort of recasting that, arbitrarily applying the 2017 change in separation requirements denies us of the rights that all others received in the exact same situation if they were approved before 2017. So the conclusion I would draw from that is that the city approved the site for a dispensary. Without this variance, the owner will be deprived of the rights and privileges of all others that were approved for a dispensary before 2017. So test number 3 is that the adjustment that we're asking you shall not constitute a grant of special privileges inconsistent with the limitations upon other properties in the vicinity and the zone in which such property is located. I think we clearly passed this test as well. So nothing is special about, you're not granting my client special rights by telling him he is allowed to develop under the rules that were in place when it was permitted for development. Had he not, had his predecessor in interest not come to the city and not been approved, they had not built out the site and not gotten the C of O, it would be a different story. But there's nothing special about letting someone develop under the rights that they earned and that they came in under. So the zoning clearance, as I mentioned, was issued, the building permits were issued, a C of O was issued. There's nothing special about operating after you have these approvals. Conclusion is there's nothing special about letting this approved project operate. Now the 4th test is whether or not the situation is self-imposed. So we can't come to you and say, give me a variance if we only need a variance because of something we did. In this situation, I think we clearly pass this prong of this test. The variance is only needed because the city is ignoring that provision in section 6-903 that says that you can assign applications to successors in interest. So the variance is also only needed because the city is trying to apply the new separation requirements to property that was approved under the old requirements. None of this is our fault. There are no other options for dispensary locations. And this takes me back to the case that we attached at number 8 in your packet. Now that case says, in that case, the judge found that, so the city of Tempe argued that, well, you, by buying this building, this other dispensary operator, where you can't do a dispensary, you've created the problem for yourself. And the court said, no. The city of Tempe doesn't offer any other place that you can possibly do a dispensary. So that's not you creating the problem, that's the city creating the problem. So I think that's important to this prong of this test, that the city has even admitted, and that's where I have attached number 9 to your packet, which is a filing that the city of Tempe made in Superior Court with regard to the owner's previous cases, where they've said there's only 2 other sites that may possibly even work for medical marijuana dispensaries in the entire city of Tempe. So it's not my client's fault that that's the case. So the city created the need for this variance and not the applicant. And so I've done probably way too much talking at this point. I'd like to reserve some time to respond, but also to answer any questions that you have right this moment, if you have any. And I'd also like, Mr. Chairman, I guess just formally for, to ask that you accept these documents that I provided to you, just as part of the record, just to make that clear.
I see. So I think what we'll do questions, and then we'll come back if you've got other people that want to come and speak too, you're saying?
Yeah, I'm sorry, and I do have one, Mr. David Dow, who's an attorney who wanted to make a few comments as well. But if you have any questions based on what I just said.
Okay, really quick, I want to do a procedural question with Steve Abramson. He's asked me to formally accept this document into our record. I don't know procedure on such things.
In that we did not have time to review the entire document, I would say that, frankly, you can accept it because no one can review the entire document in the time that you have.
So we can only acknowledge that it has been given to us?
Yes.
Mr. Chairman, and I know this procedural stuff is not what you're accustomed to arguing about, but I tried to submit this documentation several weeks ago and was told I had to bring it here today to you. So this catch-22 really, and these are all documents that have been filed with the city, or they are filed by the city, documents that are in the city's possession. We just have I have a duty to my client to be able to have this be a fair proceeding. And I think this catch-22 really isn't fair. You're not admitting anything by accepting this into the record. We just really need to have the fair opportunity to build a record. So.
Well, I can acknowledge that we've received it, but having not reviewed it, I can't do more than that.
Well, and I think, and I don't know if anyone from the city attorney's office is here, but I'm not asking you to acknowledge anything other than that they are in evidence. So when you submit evidence in a trial, you can present evidence. It doesn't mean that you have to pass judgment on whether it's convincing or not convincing or anything. If you can just acknowledge that it's considered evidence that I've presented, I think that would be sufficient for this.
Sure.
And I appreciate that. And I'm sorry to bog down with this sort of discussion.
Okay, well, let it be noted such.
Thank you.
All right. So now, questions for Mr. Rich. Board Member Noggle.
Yes, I have a question. In your presentation, you referred to rule change. I assume that's ordinance change. Did you or your client participate in that process with the city of Tempe when they apparently adopted or modified an ordinance?
Mr. Chairman, board member, I can ask about that. I guess I would submit that that's irrelevant to the situation that we're in for the purposes of what you need to look at with those 4 tests. But if you'd like, I can ask if we weighed in on that. I'm told we did not participate. We were unaware of that proceeding.
Okay, other questions? Vice Chair Frazee.
Thank you. A couple questions, I guess, in regards to the presentation. If you could go back a couple slides. Not sure how easy that's going to be.
Quick way to do it.
A lot of animated parts.
Yeah, that one should be fine. So I guess a couple questions that I'm trying to wrap my head around is the process of the acceptance. Maybe go back one more when it talked about the acceptance of the property. Yeah, so for right there with the so the use permits and approvals are transferred to successors. That applies when you buy a building, it's a tenant in place, the new owner of that building has that tenant continues to operate. With this situation, I guess my understanding is that the medical marijuana application that was accepted is not transferable, though.
Chairman, Board Member Frazee, I think it's a good question, and I think that really gets to the heart of the issue. So, and I cited the statute or the city ordinance earlier that talks about applications. Who is the applicant? And the applicant is the owner of the facility. And so under your city code, the applicant is the owner. The applicant applies, and in this case, they made Natural Herbal their representative when they applied.
Correct.
There was a use acceptance letter that was provided to Natural Herbal and therefore to the owner. Natural Herbal was acting on their behalf because that's the only person that can be an applicant is the owner under your city code. And that approval was granted, and the approvals are transferable under your city code to successors in interest. The problem that we have is that the city is taking the position and saying, well, that approval only applies to Natural Herbal because they're the only name that's on that letter. But the city can't say that because the code says this, and the city doesn't have the ability to say anything other than what the city code says. So that's this really special oddity that we've got here is there was an approval issued, and approvals go to the owner. The owner's allowed to transfer it. My client clearly is in the shoes of the new owner and even has a direct assignment of those rights. But yet the city is saying, well, actually, that approval wasn't assignable. But there's no city code that says that. There's nothing in the city ordinance, there's nothing in the law that I'm aware of that's been pointed to that says that this special approval is unlike all other approvals that are in 6-903 and is not transferable. So therefore, it was transferable. My client has it. But the only solution to this problem is either for the city to acknowledge that we have these rights or for you to issue a variance to kind of overcome this oddity that we've got here.
And the variance is for the distances from the childcare and from the residential.
Chairman Lyon, Board Member Frazee, that's correct. And I would just make sure to point out that prior to the rule change, and when the use acceptance letter was issued, this dispensary location met all of the setback requirements. And therefore, as a result of what we just talked about, the applicant's the owner's transferred those rights, the approval letter still stands, the city's acknowledged that it's still in place. That's how we get here, and that's how we get in this bizarre circumstance that's before you.
And then I guess maybe for the city, so the city's position is those approvals are not transferable because it's a different tenant.
So if I can refer to a section of the code, it is section 6-601, conditions of approval. I'm just going to read from the code. The decision-making body may impose conditions on any approval. Such conditions shall be designed to implement the requirements of this code, protect the public from potential adverse impacts from the proposed use or development, or to fulfill an identified need for public services. So yes, the code does permit transfer of approvals, but the code also permits conditions of approval, and a condition was issued in that approval letter from 2015 that authorized a dispensary for natural herbal remedies and its applicant, Jennifer Corey, only. In that same condition, the last sentence is that any person or business other than those identified herein must file a new application to determine compliance with zoning regulations. So as far as we are concerned, this is a new applicant, this is a new person or business that has filed, that did file a use acceptance request and it was denied. It is not natural herbal remedies. So according to this condition, we cannot transfer as the appellant had requested.
Okay.
Mr. Chairman, if I could respond to that, I would just say that certainly the conditions, adding conditions to approvals is one thing, but you can't add a condition that is illegal under the city code. That's not, you can't add a condition that violates the code. The code gives use permits and approvals are transferable. It doesn't say they're transferable unless stipulated otherwise or something like that. So you can't take away something that the code says you have just through a stipulation. So.
All right. Board Member Conford. Collins.
I do have a question to the city staff. So on the PowerPoint here that you provided, you're referencing use permits and approvals are transferable to successors and interest, City Code 6-903. Do you concur with that section of the code?
I concur with it. However, we cannot ignore the remainder of the zoning ordinance. And elsewhere in the zoning ordinance, it is stated that the decision-making body can impose conditions on any approval. This section of the code does not state that use permits and approvals shall be transferable. So with a condition, it may or may not be, and according to this 2015 approval, it is not transferable.
All right, thank you.
Did you also have a question, Board Member Conford?
Very quickly, we're here to appeal a variance. The issue of transfer of ownership wasn't part of that hearing officer decision, is that correct?
That is correct.
Yeah.
So the time to appeal whatever he's talking about as far as the ownership and the transfer might have been a year ago, and it's not necessarily part of our review for the appeal for the variance tonight. That's the way I'm reading it. So more of a comment. Thank you, Mr.
Chairman, if I could respond, certainly the issue of special circumstances is and has been an issue in this case, and whether or not the applicant, the appellant in this case, has the rights to develop has been an issue at every step of the way. And so I guess I respectfully disagree with the conclusion that you reached there.
Okay. Well, oh, one more question here. Board Member Watson.
Yes, I'd like some clarification. Throughout the slides deck, you've stated that there are no other locations, but when you were on the fourth test, you mentioned that there were 2 other locations in the city of Tempe. So did I misunderstand that?
All right, that's a good point. Why don't we look at what
I would just like an explanation, because
Yeah,
you gave 2 different answers.
So the city, it has indicated in number 9 there that there are 2 possible other locations. To the extent that I said there are no other locations, I'm simply, I guess, stating that there's no other opportunity for my client. There's no other location he can go. So that's my understanding.
Okay.
And I will note in the case that's referenced in number 8, it did talk about no other locations being operated or available. So that I apologize for the inconsistency there.
All right. Well, do you wish to have other members of your team come and speak?
Yes, thank you.
I'll advise you that I think we're aware of many of the basic points. So,
And I understand it. David Dow, on behalf of Image Productions, I'm not here on behalf of Park. He provided most of the ball on behalf of Park on the application. I'm for the landlord itself, the successor. And what occurred here is there was a use
I'm
exception.
sorry, could I interrupt for just a second? Do you represent the applicant?
Yes, I represent the landlord applicant because on behalf, sometimes the tenant is the one applying on behalf of the property. That's how I understand it. That's why we're on the same team.
Is the landlord part of the application team then?
The application, the variance application requires authorization of the property owner to process an application. So as far as we are concerned, there is a single applicant, and that applicant can receive authorization from the, or must receive authorization to pursue a request from the property owner. They may or may not be one and the same.
All right, fair enough. Please.
And I don't want to belabor the other variance points, but I do want to talk about 6903 from the Tempe Code. This dispensary space had been previously granted a use exception or use acceptance letter in December of 2015. In August of 2016, Image purchased this property, and in November of 2016, the city issued a certificate of occupancy after Image had purchased it. Image incurred substantial costs for tenant improvements and related features. Only in 2017 was the Tempe Code amended to significantly increase these distances. Image at the zoning level sought a variance from the zoning staff, and it has appealed it to this Board of Adjustment. There is no evidence that the zoning department was authorized to deviate from the express terms of section 6903, which makes acceptances transferable. The zoning department has exceeded its authority. There is no evidence that any department provided or approved of such authority for the zoning department to include that phrase, saying that there must be an additional application. There's no evidence that any city department conducted any due diligence on the original applicant. There was no reason to do that. There's no reason to differentiate between park and natural herbal remedies. If anything, colloquially, we could say that natural herbal remedies had much more problems than the present applicant. They had lawsuits, and they had some people in it that maybe had some other issues. But there was no issue that the city does not vet this particular type of situation. So there's no rational basis to distinguish between natural over remedies and park. There's never been a revocation of this permit. The city has stated natural herbal remedies could operate at this location, which somewhat demonstrates the special circumstances, but the absurdity of this response. There's nothing there that should impugn or deny Image and Park the opportunity to operate at this location. And in fact, it was even suggested that if we use the name Natural Herbal Remedies, we could operate at that location. We're not doing that. There's no evidence that exists by the city council, by anyone, as to why it was so important that only natural herbal remedies can operate at this location. There's no evidence that natural herbal remedies was the greatest dispensary in the world and was somehow unique. Image has expended a lot of money for this, both before and after the ordinance changed, including building permits and substantial improvements. The city knew that these expenditures were going on. We'd appropriately applied for our construction permits. The zoning laws of the state of Arizona are construed for the benefit of the land and are not personal, generally, to the persons and entities. Trying to impose this situation would pretty much destroy a lot of development out there if this was imposed on every project in Tempe. Think of how ridiculous that would be, that when you buy it as a new landowner, all of the rights go away or things like that. It's not reasonable, it's not equitable, it's not fair. There are special circumstances why you should grant this variance. You have to remember the overlay of the whole process here is the citizens' vote on Prop 203, which authorized medical marijuana. And in there, it was specifically stated that the cities could only impose reasonable restrictions upon medical marijuana dispensaries for their locations, what they can do, what they can't do. Taking that into consideration that the citizens voted for it, and citizens of Tempe voted highly for it, for Prop 203, you need to consider, is this reasonable under the circumstances to deny Image and Park the variances under these circumstances? We ask that you grant those variances. Thank you.
All
Any
right.
other questions?
Questions for Mr. Dowd? Vice Chair Frazee.
Thank you for your presentation. I guess trying to understand the process from previously, when Image and Park was here in 2017, they were applying for a use permit. The zoning hearing officer denied that use permit. Board of Adjustments agreed with that denial. So the next step would have been to the court. And that was a question, did that take place?
I was not involved in that, but my understanding is there was some sort of court procedure, and I don't know that it was timely appealed. That's my understanding, but I was not the attorney of record back then, and I apologize for not knowing it completely.
Okay, so now it's Image and Park
Image and Park,
are
and we're
applying
asking
for
for
a
this,
variance,
and we're asking for a variance,
which, okay,
and that's the difference.
okay, thank you.
Yes, Board Member Collins.
Thank you, Chairman Lyons. I want to follow back up again with city staff, again, back to that letter that he's referencing and you brought up. The letter that gave the approval of the permit or the license had a stipulation in there that it could not be transferable. Who made that decision? Was it who exactly made the decision and signed that letter?
That was a decision of the planning division.
Okay, so it did not go up to review by anybody else?
Those letters are not typically reviewed by other departments.
Thank you.
Ms. Stovall.
I would like to make a clarification regarding what the board saw before you in 2017. It was not a use permit request, and it had not gone to the hearing officer. So medical marijuana facility applications are reviewed by staff, by city staff. So we denied the request for the dispensary, and you heard an appeal of staff's denial. So, of the zoning clearance. So the applicant submitted an application to the planning division. That was a staff level decision. That decision was to deny, and that applicant at the time appealed that to the board. So no use permit was involved.
Can you remind us of the Board of Adjustment's decision at that time?
It was to deny the appeal.
Yes. Board Member Collins.
I have an additional question. I hate to keep pounding on this for city staff, but so I'm trying to wrap my head around this. The letter was given to them. They were approved with a stipulation it couldn't be transferred. For the other businesses that are operating as medical marijuana dispensaries in Tempe, did they receive the same stipulation when they were given the license or the permit that they could not be transferred?
Yes, they did. This stipulation, as far as I'm aware, is included in any use acceptance letter for either a dispensary or a cultivation facility. It is standard, yes.
So to follow that question up, why is it only, it sounds like it's only included in requests for medical or marijuana-related facilities. Is that what you're saying? That stipulation is a standard for only for medical marijuana facilities?
Yes, it is.
That was my current question I wanted to hear. Thank you.
Well, if I may, are there not stipulations of other varieties for, right? So they're not the only ones that end up with stipulations on their letters of acceptance. Ms. Stone.
Just to clarify, if a use were to require a use permit and would now go before the Development Review Commission, we do have standard condition of approval that they have to request transfer to another user, and that transfer would be done at a staff level. So an application would have to be filed by a different use for a use permit, sorry, different business for a use permit to transfer it.
So you're allowing the transfer in those cases, but you're not allowing the transfer for medical marijuana facilities?
With review of the new business application, yes.
All right, thank you.
Mr. Chairman, can I just follow on with one point with regard to something that you said? Certainly there are stipulations placed on other, on use permit type of applications, but I guess the point I just wanted to remind the board of is that this particular stipulation directly violates the city code. And I would suggest that the other stipulations that you're familiar with, such as, you have to paint the building this color, or, the windows have to look like this, or you have to have this many parking spaces, those are not violating the city code directly. So I think however the process was created to put this stipulation in place, there was either they forgot about this section of the code, or otherwise, we're doing it without really any legal authority. So I just wanted to make that point.
Okay, fair enough.
Any further questions?
I don't think so. Is there anyone else from your team that wishes a few moments?
Not at this time, thank you.
All right. Well, thank you. All right, so at this time, let me just see, does anyone have any more clarification questions for staff? Because we've been asking them frequently for clarification. Now would be a good time to get some more if we need it. All right, Board Member Tracy.
Thank you. So I have a couple of questions. It was previously stated that the applicant is one and the same as the property owner. So would the stipulation letter be issued that was issued really be for the property owner or only for that tenant?
So city staff did not make the statement that the business is one and the same as the property owner. I believe that was the appellant's comment. That is not correct. As far as we see, you can have a property owner authorize someone to pursue an application so they are not one and the same. And according, again, to that 2015 approval, the use was authorized for natural herbal remedies dispensary, not for the property owner.
Okay. Then my second question was, did the applicant have the ability to appeal that stipulation that was issued?
Yes, yes.
All right, fair enough. So let's go to our public comment section. Again, if you would like to make comment on our case, we can grant you 3 minutes up here. We have some white cards at the back of the room. If you would fill one out and give them to city staff if you wish to speak, we can accommodate you. Mr. Rich, we'll give you a chance to come back and respond in a moment. I have also, here's David Dow. We'll invite you back up in a moment. Let's see. William D. Bishop, I believe I see here. Yeah, would you like to make comment?
Sure, thank you. I'm here as an owner of one of the office condos in the same professional office condominium that the proposed dispensary wants to open. I'd like to point out that natural herbal remedies, this is certainly not the same business. I don't believe there's any individuals from Natural Herbal Remedies, the prior applicant that is here today. And my understanding is it's still in business. Natural Herbal Remedies is still around. So it's not like a defunct business that was bought by this, but they are still around and operating as a dispensary in other locations. So the hearing officer had it right in the first place. The applicant is trying to bootstrap on an application that was not their company's and they had nothing to do with. With regard to the child care center, I don't see the distinction between a fitness center, child care center, and another child care center. This is a big child care center. There's tons of kids there, and I don't think there's any definition that states that there are certain kinds of child care centers that are somehow exempt from this. So I would urge you to put that one aside. This is a beautiful professional office complex, attorneys, CPAs, counselors, etc. Just do not think that this particular business is appropriate in this particular location. It's not a fit. One of the reasons, my understanding, Natural Herbal Remedies didn't come in at that time was that, and this has been brought up in the prior stuff, is that there were CCNR issues at the time, and they left it behind even though they got approval from the city. That was one of their obstacles. And so when these folks came in, these new folks came in, they knew that was another obstacle at the time, and they built those improvements before there was any kind of litigation going on or anything else. So when they talk about we built all these things thinking we were going to do this, there were still obstacles in place. So they took the risk. They took the risk at that time to do the improvements when they hadn't even gotten through the process with the condo association at that time. So my understanding is, and I'm not sure if I'm correct on this, but that not only is this the same applicant, but also that there are specific time periods that the operation had to be open, and I'd have to defer to the city on that, but that it was not open within the time period that Natural Herbal Remedies needed to open it. So my understanding, there were timetables that were involved. My understanding is that there was a court hearing from just listening to what I had today, and that court decision was not timely appealed, I think is what I heard.
Bishop.
Sure.
Sorry to interrupt. I should have clarified before. Typically, we like to ask comments be held to about 3 minutes. So would you wrap up your remarks, please?
Okay, I will just summarize. I'm just going to summarize that the hearing officer had it correct, and I would urge this group, the chairperson and the city council people to verify that decision.
All right, thank you. Any questions for Mr. Bishop? No, thank you. All right. Jeffrey Gross. And again, I should have said so before, but we've got some lights here. When it turns yellow, you're a little low on time. When it turns red, I'll probably ask you to wrap up.
Thank you, Mr. Chairman, members of the board. Mr. Schweiker, David Schweiker, has also submitted a request to speak. He has asked if he could donate his time to me, so I have a little bit more time than 3 minutes. We had like 45 minutes from the applicant.
The applicant is granted as much time as they require. We do not allow people to stockpile their time. If you wish to make your remarks, please do so.
Okay, thank you. Again, my name is Jeffrey Gross, Barry Riddell, 6750 East Camelback Road, Scottsdale. I represent the owner of the properties immediately to the west of the proposed dispensary across Priest. You've heard a lot about being judges. You're judges. You're considering the evidence. The applicant has the burden of providing you with evidence, sufficient evidence, evidence that is going to change your mind that the hearing officer was wrong, or that the hearing officer was right. You've heard from Mr. Dow, there's no evidence presented about this, there's no evidence presented about that. That's not the city's job. It's their burden to present evidence to you, not to tell the city that they should have presented evidence to the hearing officer or there was evidence lacking before you. So they have to make their case to you, and they haven't done that. And let me go quickly through the four elements. Our position is that because of two crucial facts, the tests that everybody agrees applies here, the four-pronged test can't apply, that can't be met. When the approval was granted in 2015, there were two conditions. There were two conditions. Neither one of the conditions was met. One of the conditions was, and on the letter of December 22, 2015, that the Natural Herbal Remedies Dispensary and its applicant, the approval will expire after 60 days from the date of this letter, 2015, unless an application is submitted to ADHS to receive an approved dispensary certificate for this location. That was never done. And the other one is it's not transferable. So when the new owner acquired the property, when the application, when the approval expired, this property became just like any other property in the city. There was no longer an approval. It had expired. The certificate remained with the property. The new property owner acquired the property subject to that in 2016. They knew what they were getting into. Once that happened, once the property became exactly like all other properties in the city, they were subject to the new spacing requirements that came in afterwards. So there's no special circumstances because they're just like everybody else. There's no denial of special privileges because they're just like anybody else. This is a self-imposed hardship. They acquired this property, they acquired the lease because they wanted to make money because they knew this was a location for a dispensary. They say it all over their letter. They're at an economic disadvantage. They have substantial expenditures that they need to get out of this. That's a self-imposed hardship. They regret the fact that the approval had expired and that the certificate was not transferable, and they want you to now excuse that by granting a variance. Thank you very much.
Thank you. Question, if you would. Thank you, Vice Chair Frazee.
Just a question. So you represent, you're saying the other condos in the building or the land to the west?
I sped through that pretty fast. I represent the property owner immediately to the west across Priest. We refer to it as Emerald I-10. It's called Emerald Center. It's owned by by LLCs that are connected with the Tate family. Mr. Tate's a very experienced developer. He opposes this.
Thank you.
No other questions. Thank you. All right. Mr. Schweiker.
And I won't use up my whole 3 minutes, but just real briefly, I represent Dr. Rima Peters. We have a letter that's submitted that's in your packet as the background information. We submitted it a long time ago. Anyway, suffice it to say that our understanding is that there are 4 tests that you have to meet for this and that the applicant does not meet any of those tests, and especially the first one because they're not really the applicant. That application was not transferable. And so we just are a property owner in the complex, and we respectfully ask you to uphold the hearing officer's decision. Thank you.
Any questions? Thank you. All right, so last chance. Anyone else from the public wish to make comment? I will close the public comment. And we'll ask our appellant to come back and respond.
Thank you very much, Mr. Chairman, for the opportunity to respond to some of the things you just heard. Let me start with what Mr. Gross said, because I think it's important, because it's wrong. So he took you through a scenario that suggested that that this application, the approval that was granted, had somehow expired because a certain benchmark was not reached. Well, it's just false. That's false, and it's in your packet that I provided you. Number one, as we've gone through most of this before, but tab number one is that approval letter from, sorry. Let me make sure I've got the right number, sorry. Number three, I'm sorry, is the approval letter from the city of Tempe dated December 22nd, 2015. Mr. Gross is correct that it said that Natural Herbal had to apply within 60 days of the date of that letter. However, as you will see in number 7, that on January 5th, 2016, Natural Herbal applied to the state, as was required by that letter. So it did not expire. What he said was false, and the evidence is in front of you to that effect. I want to also emphasize for you one more time, because it came up, and I think board member Tracy asked a question about this, so I want to make sure we get this right. Your code, and I can back up, if you can get my back up there. Thanks. Your code at section 6-201 talks about who the applicant is, and I want to, because that was a point that you brought up, I want to make sure I refer you back to that so we can all look at that. It's back towards the beginning. Whoop, I skipped it. Sorry, apologize for that. Trying to jump around. Okay, so Tempe Code 6-201 at the bottom of your screen there says an application may be initiated under this code by the City Council or by the owner of the subject parcel. So the owner was this company called Pathfinder. And if you look at, and I won't jump through here, but I can point you to, this is tab number 1. If you look at tab number 1 and what I provided you, that's the owner authorization letter from Pathfinder, the owner of the property, saying, Natural Herbal, you can go and be my representative at the city and process this application. But it wouldn't be possible for anyone other than the owner to be the applicant, because that's what your code says. The code says the owner has to be the applicant. And so, in that letter from Pathfinder, it says Pathfinder TRF6 LLC is the owner of the above referenced property and has the ownership rights more fully described, and then it has a legal description. But I think that's just really important, and I want to make sure you understood that. It sounded like that was a question that you had in your mind, and so I wanted to make sure that we revisited that issue. As most of you probably know, there was a mention of CC&Rs. One, I will submit that what the gentleman said is not true, but two, CC&Rs are a private contract, is outside of the scope of what the city's concern is anyway, and so that is not something that I think is something that you can consider in any event. Mr. Gross also mentioned that we've suggested that there wasn't evidence of this or there wasn't evidence of that. Well, it's your job to weigh the evidence that's before you and to evaluate whether or not the hearing officer made the right decision. If the decision that was made by the hearing officer is based on things that aren't in the record, then certainly it's up to you to recognize that and decide whether you think that is a reason for you to change the position that the hearing officer had. So to sort of sum up here, this is a strange and different scenario. By granting a variance in this situation, you are not in any way sort of unlocking a situation where all the rules have changed and now 100 dispensaries are going to come in. I challenge you to find anybody on earth that's got a situation like this. They've got the acceptance, they built it out, there's been the transfers, the law changed, the city won't acknowledge the transfer. Now here they are, there's some oddities with the setbacks from what really is a child care facility, the dramatic change in the setbacks. And you have an opportunity to sort of remedy all this and put it to bed and allow this one dispensary in this one unique situation to move forward, which I think is the right answer. I'm happy to answer any questions that you have here. I appreciate all the time you've given me and listening to this complicated scenario. So thank you very much.
All right, so questions for our appellant? Quiet tonight, all right. Well, then we'll thank you.
Thank you.
All right, so board members, now we discuss amongst ourselves and consider the facts. If you'd like to weigh in and express your feelings, or we can ask questions of each other to weigh these things out. Board Member Collins.
Thank you, Chairman. I usually don't speak on when it goes around, but I will say that I have a concern about the letter that was originally approved and the stipulation that was put in there that it could not be transferable, because it sounds to me, and this is just my interpretation, that the stipulation of non-transfer is being used solely for medical marijuana facilities. And Board Member Tracy asked the question is whether there is a right of appeal of that letter. Well, I wouldn't expect someone that got a letter of approval to appeal their letter. They would not have thought that it was an issue, that the letter was basically approving it with the small stipulation that you couldn't transfer it. So I wouldn't have expected them to think ahead that maybe they would transfer it later. So I just bring it up as a question, and I hope that that's not a standard policy that city staff has, that the stipulation only applies to medical marijuana facilities when they're approved.
All right, question for Ms. Stovall. Are stipulations only attached to medical marijuana use permits?
Let me make sure I understand the question. Is the question whether or not approval letters for other types of applications contain stipulations?
Yes.
They most definitely do.
Well, let me speak up a little. That's not my question. Of course, any application can have stipulations. So I would clarify your question, Chairman Lyons. Are this specific stipulation of not being transferable applied to any other business other than medical marijuana?
To my knowledge, no. However, I would like to state that, as I explained before, the code does allow conditions of approval, and those conditions of approval may be unique to a specific application and application type.
All right, thank you. I understand that. So basically it sounds that city staff has made a decision, and that's what the standard is. I just want to make sure I understood that. That's the standard for these type of applications, and it's basically a city standard established by city staff.
Correct.
All right, other comment? All right, so I'll weigh in. I usually like to wait to the end. My interpretation of those stipulations is by granting the use permit, the city doesn't want to see that business be able to continue on in perpetuity without regular checks against the zoning code. So every time the business changes hands, there's going to be a new check to make sure they're still in conformance. That's how I understand those stipulations, and I think that this is exactly that case happening, is when we had revision to the zoning code that put these people in a bad situation, and as it changed hands and the use permit being non-transferable, well, they have to check again, and we find now that they don't match the current zoning, so that's why we have them here asking for variance. So I would then turn to the 4 criteria and look at the special condition. Does anyone else have this? Are they denied a privilege? Are we granting a special privilege? And is this something of their own making? And from where I stand, they don't pass those 4 criteria. It is an unusual case, but the fact that they are being measured up against the zoning ordinance and found wanting is not a special condition. It's just the history is rather unique, although lots of projects have unique histories. I'm not aware of another dispensary that we have granted a variance to have shortened separation distances. If we did shorten those distances, we would be creating a special circumstance that no one else enjoys. And I rather think that while it is a painful fact of the risk they took, the situation they're in, I do believe to be of their own making. I believe when they made that purchase and decided to set up the business, they understood that there are some hurdles that they would have to address. And I think if they weren't aware, they certainly should have been, that there was some risk involved. So those are my feelings. Anyone else wish to make comment, or shall we hear a motion? Mr. Abramson.
Thank you, Chairman Lyon. I just want to add that in the past, we've had legal review of permits that have allowed for a limit on the transferability of the permit. So it's gone through the process in the past, I mean, legally from the attorney's office. Specific types of permits, I'm sorry, I'm not prepared I don't have that information at hand, but it has been allowed through legal review.
All right.
Thank you.
All right, so if there are no further comments, I'll entertain a motion.
Mr. Chairman, I have a motion.
Board Member Noggle.
I move to deny the appeal of the hearing officer's decision to deny a variance to reduce the required separation requirements for a medical marijuana dispensary from a residential use in a child care facility for 8611 South Priest Drive.
Do I hear a second?
I'll second.
All right, so motion to deny the appeal from Board Member Noggle and seconded by Board Member Watson. By way of clarification, a yes vote, if the motion passes, this will have the effect of denying the appeal and the appellant will not be receiving these variances. So, all those in favor, by show of hands, please. And those opposed. All right, so the motion passes 6-1 with Board Member Cullens in the dissent. All right, so that's our agenda for the night, ladies and gentlemen. Do we have any staff announcements that we should take care of?
Chairman Lyon, thank you.
All right, ladies and gentlemen, we are adjourned.